Okay, well, we really do have a panel of experts. I know sometimes people say that, and it's a nice thing to say. In this case, it's true. And so if I can have everyone's attention, we're going to delve right in. Someone pointed out that when I announced the program, I don't recall this, but they said that I identified the program as Ideas for Communications Law and Policy Reform in 1913. Is that true? That's probably because there are times when I think that we're still stuck around 1913, but that was not deliberate. Okay, so here's what I'm going to do. I've asked, by the way, each of the panelists to speak initially for no more than 7 minutes because we want to have a dialogue back and forth, and then again with the audience for any questions and comments, and perhaps it'll even be less than that. Again, what I'm hopeful they'll do is just, even if they're not able to lay it out with a 100-point plan, is to get some ideas on the table, just get them on the table. I'm going to introduce them. We can just do it the way that they'll speak here. I'll go down the line. You've got the speaker bios. I'm just going to tell you what they're doing, and not much more than that, their current positions. And so first will be Rob Atkinson. He's president of the Information Technology and Innovation Foundation. I will say that I know Rob has a new book out too, and I've heard a lot of good things about it. So after you order that new Free State Foundation book, be sure to take a look at Rob's book. No, I'm just kidding. His is out. You should get his book. James Gattuso is Senior Research Fellow in Regulatory Policy at the Heritage Foundation, and James has just been following telecommunications policy for a very long time, and not only is knowledgeable about that, but regulation more generally across the board. But today we're going to focus on communications policy. So next would be David Honig. David is President and Executive Director of the Minority Media and Telecommunications Council. And I'll just say about David that I'm really pleased you're here and sort of relevant to your question that you asked. Obviously, David, of course, with his organization, he has a focus on increasing opportunities for minority in the media, and I think that's an important perspective and an important voice actually to be heard. But I will say this: not only as over the years I've gotten to know David better, he's not only knowledgeable about those issues of particular concern to minority community, but has, I think, some good ideas about telecom reform in general, and that's another reason I'm happy he's here. Finally, Adam Thierer. Of course, most of you know Adam. He's one of the real experts in the communications policy area, especially in the media area, but others as well. And so Adam, we've been mentioning books. One thing I'll say about Adam, he's a prolific book reviewer in addition to authoring his own books. So I'm hoping he'll take a look at our new book when it comes out. So we're going to start with Rob and take 5 to 7 minutes to get some ideas on the table, and then we'll go from there. Rob.
Okay. Thank you, Randy, for having me. It's always a pleasure to be at your events. So I have 7 minutes to completely rethink U.S. telecom policy. So I'll start right in. Look, I think the problem is in '96 we had an act that was in some ways went down the wrong path. It was an act focused largely on telephony, on the PSTN, and really had a view of the world around competition, which I think was unrealistic, and as we've seen, never really played out. And I think we have to recognize that world was never realistic, and we've got to focus on what the world really is, not how we think it should be. And what the world really is, it's basically a world of intermodal competition with IP-based networks. And we should just recognize that's what it's going to be. We shouldn't be trying to get excess competition. We have competition. It is what it is. And I think it's working pretty well. So this whole focus of we just more competitors is better, I don't believe that's the case. So I think we also, if that's really what we're saying, we need to think about what broadband is, what are broadband IP networks in that context. And I don't think, pretty clear arguments we've heard from the Commissioner and others, they're not Title II. But I don't think they're Title I either. There's something beyond or between those two things. They're not exactly the same as a piece of software. So I think we have to recognize that they're not Title I nor Title II. I would also argue broadly that I think we have to recognize that we need to be committed to intermodal competition and don't let the desire for intramodal competition get in the way of doing important things that certainly are cost-saving measures like retiring the copper network. Just because we think there might be a little bit of intramodal competition that can ride on it, and phasing out the overall PSTN network. I also think we've got to recognize that competition works, but it really only works, I think, if we don't allow price discrimination. Oftentimes people will say, well, how can you say that competition works if you only have one provider in a market? And the reason is, as long as that one provider is charging the same price in that part of the market where there's only one competitor that they have to charge in the part of the market where they're disciplined by competition, you don't need multiple competitors in every marketplace. But if you change that, then you have to go down a different road. So I think competition generally works as long as we have that particular provision. And I think, again, just overall broadly, I think we have to recognize that more pipes means more cost. This is something I think a lot of people disagree with us on, but building more pipes to get more competition fundamentally raises prices. Building a pipe costs money. Now, if somebody wants to do that, like Google to their credit in Kansas City, great, good for them. But we shouldn't have a policy that says, let's get more pipes, let's subsidize overbuilding. I think that's a mistake. Secondly, I think we've got to figure out how to get USF right. Again, the Commissioner talked about how USF contributions are increasing. In some ways, the fund is unsustainable. And I think the Commission generally got it right in their decision. We have to think about both nomadic and fixed services in the USF world. But I also think we've got to bite the bullet and say that there's no reason users in high-cost areas shouldn't be paying as much as or not more than I'm paying our other users in low-cost areas. The idea somehow that we should be subsidizing through low prices high-cost users, I think is a big mistake. Secondly, we've got to recognize that we're not going to ever provide broadband to everybody in America, at least non-satellite broadband. It just, at least for the foreseeable future, we're not going to be able to do that. And we got to accept as a nation that that's okay. We don't have to have fiber to the igloo to make this a successful project for our country. And therefore, the projects that have some reasonable cost-benefit ratio should be the ones we focus on, and not the ones where that just doesn't make any sense. I would also argue that we need to just give up on the notion that small ILECs are some inherently good thing. I've long argued, at least long being in the last 2 months, because of our book, that the federal government should be size agnostic. We should neither favor big companies nor small companies, but we have this sort of ideological thing in our nation that small is better than big. Small is usually more inefficient than big. One of the great things small companies do is the only area that small companies outperform big companies on is disability payments, which I don't think is a good thing. Workman's comp. That's really true. And unemployment insurance. So those are the only two things. They pay lower wages, they have lower productivity, they invest less in R&D, they export less. But that's sort of a side argument. My only point to say is I think we need to have a policy that encourages ILEC consolidation because scale matters. I would also really just say we should be doing no more overbuilding. I think overbuilding is a waste of valuable resources. We need to have a policy that puts infrastructure where there isn't, but not two of them. Got 1 minute and 34 seconds left, so I think I just on 706. I went back and I read 706 recently when the new report came out, and I'd read it before, but I'd forgotten what it said. And So the problem I have with 706 is it basically has two problems with it. One is it presumes that competition is the answer. I don't think the law should presume knowing the answer. It should say there's a problem, we should try to fix it. But it says more competition is the answer. I don't believe more competition is the answer to high-cost areas not having broadband. In some ways, less competition might be the answer. And secondly, it has I would, if we ever redo 706, and maybe it's something the commission could do on their own, I would break it into two parts and say, have we had timely rollout to places that can have broadband that don't need a subsidy? In other words, where the market where you would expect the market to work, has the market worked? Then we have a separate set of households in the U.S. where it's going to cost more than what the price would get. So that's where the market wouldn't work. How are we doing on that? I think the notion that we're combining all of this together really misses a critical point. So I would redo 706 around that. Two quick things in my 24 seconds now. Oh, wait, this is one of the great things. You can use this if you want. I think we need to, on the broadband part, we need to focus on what the real problem is. Look, the reason why the U.S. lags in the OECD ranking is not because we don't have good broadband, it's because we have people that don't have computers. That really is the problem. Vast numbers of Americans compared to a country like Finland don't have computers, and they don't have digital literacy. So if we want more broadband, we've got to do that. I give the Commission credit because they're increasingly focusing on this question of digital literacy, digital ownership. I think that's an important thing to do until we get close to 95, 98% adoption. And lastly, on spectrum, we, again, give the Commission credit on the spectrum auctions, we've got to do more. But I think the big low-hanging fruit there is we just got to get tough with the federal government, non-FCC part of the federal government, who are spectrum hogs and are really wasting spectrum. And could give up a lot of it and just choose not to. And the spectrum sharing is certainly one path, but I'd hate to have the spectrum sharing be the sort of thing that gets them off the hook. And lastly, we need to be reviewing spectrum transactions from the basis of consumer benefit and competitive impact. The public interest is best served by allowing those carriers who are doing the best job of investing in their networks and attracting and retaining customers to be able to acquire sufficient spectrum resources to serve customers well. Every time we divide spectrum for these other reasons, we introduce inefficiency, and therefore we should just recognize we're not going to have massive numbers of wireless providers. It's just not the way the market will work, and we need to make sure that the companies that are doing a good job get the spectrum they need. So with that, I'm out of time. Thank you.
Rob, that was really, that was really terrific, and that was so good. If you had needed more time, I would have given it to you, but you did that really well. And I particularly appreciate, honestly, the way that you are able to explain that necessarily just creating more competitors is not ultimately good for consumers or consumer welfare, because frankly, I have to say, I think at this this particular commission, more than most, or more than it should, I would just say, there's, there is this notion that you can they ought to be managing competition, I think, managing competition to create more competitors, and from the economics point of view, I think you explained that's not always a good thing. Finally, when you were talking about the spectrum, you mentioned OECD, I think. Did anyone see, I think it was just in the last 2 days, there was an item in Communications Daily, may have been in TR Reports too, I don't know, TR Daily, but it was something about a test. Someone came out with results of a test on the wireless speeds in London and New York, and it was the speeds in New York for wireless were how many times faster than like 20 or who knows the answer? It was fast, like 20 times faster than in London. I don't know that outfit that did that, but when I read that, I wanted to say, to be able to get Mike Copps and say, who pointed to every one of those, always talking about over in Europe, and there was in London that their speeds are 20 times slower than a download speed for wireless in this country, if that report is even half accurate. James Gattuso, you're up.
Thank you. And Rob, I have to say, I'm going to use my analog time device here. It's a nice circular motion. It's the newest thing. Everyone's going to have this pretty soon. This is the debate season in Washington, D.C. and around the country, so I thought I'd start with a reference from one of the great American debates from the past. I think the question facing the FCC today is the same posed in 1992 by Admiral James Stockdale. Who am I and what am I doing here? Within living memory, the FCC has always had a defining challenge. In the 50s and 60s, it was the fight for long-distance competition and breaking up Ma Bell. In the 80s, it was a battle over the consent decree restrictions and the baby bells. In the 1990s, there was the endless struggle over unbundling. Speaking of endless, most recently, we've had the battle over net neutrality. All of these have been important issues where the FCC took a key role and were, if not settled, the FCC what was the decider. It's not clear, however, what is next on the horizon for the FCC. It's not clear what big issue, if any, will dominate. Frankly, the biggest communications and tech issues of our day are being fought out, are being debated outside of the FCC. It's Federal Trade Commission, Department of Justice, even arguably the Librarian of Congress has a bigger role in the tech industries than the FCC. Increasingly, the Commission seems to have lost its purpose. I don't say that like it's a bad thing. It reminds me of the USDA official who was depressed because his farmer had died. Think about it. The FCC was largely established to regulate broadcasters and telephone companies. Very unique market conditions, very unique and comprehensive regulation was developed to address those situations. But traditional broadcasting is shrinking rapidly, and old-fashioned telephone service has become a curiosity. The industries look more like the postal service than the dynamic future industries of tomorrow. Now, of course, video programming service and telecommunications broadly defined are doing fine. They are growing, but the specific industries, the specific technologies that the FCC was created to address are not. Now, much of the FCC's efforts in recent years has been addressed to expand its turf beyond these shrinking industries into the new, growing, innovative technologies that are appearing. But these industries don't require the industry-specific, comprehensive regulation of the technologies of the past. They are, if not perfectly competitive, certainly not perfectly competitive, but do not exhibit the monopoly characteristics that the 20th century industries did. Competition, consumer protection, privacy can, I believe, be handled better by other agencies rather than an agency dedicated to those specific industries. Now, this all may sound like I'm leading to a call to sunset the FCC. It's not. I've been down that road a couple times before. It's not going to happen anytime soon. And I think politically it's probably a waste of resources to advocate that. The FCC is here to stay. But I think that instead of looking to expand its turf and develop a role in regulating these new technologies, the goal of FCC regulators should be to draw a line around its own duties. Let it regulate the industries that it now regulates and do no more. So what would and what should an FCC regulator do? There is quite a bit. And most of these I think we've discussed already today, but let me just go through the list. Rationalized merger review. The FCC simply doesn't need to compete with the antitrust authorities in determining whether a merger will help or hurt consumer welfare. Ideally, the goal should be to limit review to a determination that the acquirer is qualified to hold licenses. That fulfills the Commission's duties under the statute and allows the competition authorities to make a decision based upon well-established competition law. Secondly, it should start using cost-benefit analysis, or more precisely, regulatory impact analysis, to review, to assess its proposed regulations. Every executive branch agency already has is under this requirement, has been for 30 years, as is most other independent agencies by statute. The Securities and Exchange Commission is subject to regulatory impact analysis requirements. The Commodity Futures Trading Commission is under cost-benefit analysis requirements. I believe the FCC is virtually alone, perhaps with the exception of the new Consumer Financial Protection Bureau, in not having a program of assessing formally the impacts and alternatives to its regulations. This is a screaming exception to the way that regulation is done elsewhere in the country. Third, drop net neutrality. Now this is, frankly, politically a litmus test. Net neutrality, I think, to the telecommunications policy world is like what healthcare is to the broader policy world. It's a defining issue. If you're for it, you're on one side of the fence. If you're against it, you're on the other side of the fence. But I don't think that this need be such an ideological divide. The basic question behind net neutrality rules is competition. Do consumers have choice? Do they have alternatives? That, again, is a competition question and should be left to the competition authorities. I think generally the FCC should not be the one deciding that. It does not have the expertise, it doesn't have the traditions, it doesn't have the precedent that the competition authorities do have. By the way, this does not mean that the FTC is perfect. I agree with everything the FCC does. In fact, I think its recent actions show that it is unlikely to be a paper tiger, that if you're worried about competition, it has the ability and incentive to act. Just quickly, two other things. Take down antiquated broadcast ownership rules. As the commissioner pointed out, the last thing in the world we have to fear is a combination of the power of newspapers and the power of broadcast television. Those, 0 plus 0 equals 0. So I don't think that should be a concern. And lastly, and this is one area where the FCC should be more involved, open up spectrum. I associate myself with Rob's comments. The FCC as a government agency should go after the federal government and dig out spectrum that is being underused. And that may be the most important thing that the commission can do. Thanks.
James, thank you. So David, you're next, please.
Randy, thank you. I'm going to find myself in agreement with about 70% of what's been said, and I hope I'll have everyone's indulgence on the other 30. One of the premises that I think all of us coming at these issues from different perspectives would or should agree on is the fundamental principle that there shouldn't be regulation unless it's supported by a showing of market failure that harms consumers or imminent failure, where the only way to have an efficient, well-functioning, fair marketplace is through regulation. So one thing that we often forget when we look at that premise is what is an example of where there is market failure. I think for about the last 60 or 70 years, federal policy, and certainly since 1971 or so at the FCC, but their policy, has been that invidious racial discrimination, gender discrimination, that's completely irrational, that distorts in horrible ways the way the market works for people throughout their lifetimes. Not only is immoral, but it's unsound economic policy, that when you have vast numbers of people who, for no good reason, are denied the opportunity to fully express in the marketplace their inherent creative, managerial, and entrepreneurial abilities, that's inherently inefficient. Labor is an input to production, and in no way would any serious economist suggest that it's okay to simply say we're not going to consider a third, a half, however much of the market because of some irrational reason. What that does to prices and to consumer welfare is well documented. Diverse companies, again and again, studies do better in the marketplace, deliver more value to shareholders. So that's important for the commission to deal with, and it quite rightly has done so. One of the other things, though, that we have to consider, and we meaning, of course, I run a civil rights organization, is the impact of neutral rules on our constituency, which is people of color in media and telecom. I'm not uncomfortable at all with the basic formulation of the case most recently where the Supreme Court spoke on this, parents involved, 2007, the school case, where Justice Kennedy's opinion basically said, first, state actors must essentially exhaust race neutral means of addressing inequality and discrimination before they can consider race-conscious means of doing so. And second, that it's okay, in fact, is a good thing to keep track of these things and to look at the unintended consequences of neutral rules and just to see what impact they have on these important social goals and on preventing market failure. So what does that mean for us in telecom policy? Let me just give wireless regulation as an example, because that's something we focus on quite a lot. And the reason we do is that it's the first technology in history for which people of color are leading the nation in adoption and in use, about 15 to 20% above the level of other Americans. MMTC has given this a name, the Minority Wireless Miracle, and we've also given a name to what we think it will lead to in time, which is permanent first-class digital citizenship. Now, we've looked at unintended consequences of rules, and just to give you an example of where we've come out on some of them, using this paradigm, as many of you know, we ended up opposing much of net neutrality. We supported rules against blocking. We supported the initial Powell principles, which were premised on transparency, and really didn't see much need for the rest of it. We endorsed the AT&T T-Mobile merger. We favored the use of shot clock for municipal towers. And we favor not only having incentive auctions quickly, but we wish they had had them yesterday. That's not soon enough for us. We endorsed having them conclude by December 2013 and don't understand why it should take another year and a half, given the current needs. Spectrum shortage is real, the spectrum crunch is real, and we hope we won't discover this when we start in January experiencing reduced quality of service and calls being dropped. So the other way that we look at these issues is, of course, the other half of the Parents United paradigm, which is, what is the Commission doing to look at race-neutral means of addressing this problem? And unfortunately, not very much. I hate to say this. The MMTC and some 49 other organizations have before the Commission 71 race-neutral proposals to advance minority and women participation in media and telecom. Some have been pending for a very long time, including some over 20 years, virtually unopposed. The FCC's own diversity committee has endorsed most of these. Just to give you a couple examples, there's a proposal that actually was proposed by the National Association of Black-Owned Broadcasters in 1990 to say that, say you've got 8 radio stations in a market, that rule was created so that you'd have new voices be able to come in if you restricted some of the other ones. So what if that broadcaster causes to come into existence a new voice? Then they can get a 9th station. All the civil rights organizations have supported this. Almost no one, I think Free Press is the only organization that's opposed it. 22 years, no ruling. We've endorsed, as have some others, taking AM radio. 2/3 of minority-owned radio stations are in that heritage technology, migrating it over to channels 5 and 6. There's an advisory committee looking at it. No progress since the 8 years that it's been pending. And foreign ownership is a big subject that's been in the press a lot. Many of you know I lost the Fox case in 1995, and I've switched sides because circumstances have changed. And I realized that if that case were litigated today, I'd be on the other side of it. The market has changed, and if we're going to have any intellectual integrity, we have to realize that. So we now support, as an organization, as do virtually all of the other national civil rights organizations, relaxation of foreign ownership, because there's not much access to capital for broadcasting in this country, so let's get some opportunities for foreign capital to come in, which inherently will mean more reciprocity so that we can expand into foreign markets. It's a global economy, and it's about time we had broadcasters be able to benefit from it in the same way as other technologies do. I think it's interesting, Commissioner Kopp's approach to all of this, these pending proposals, was let's get the commission to rule on one every month until they're done. And unfortunately, that he's left the commission and that hasn't happened. So, because I've got about a couple more minutes, I wanted to...
Just about one more minute.
I got one more minute. I wanted to let you know, it's been reported, we have a new Telecom Act task force exploratory committee. We're creating this task force. Many of us in the room, I think some of you in the room, are members. And we're studying particular means by which the act could be reformed in a way that would advance consumer welfare, and particularly for minorities and the underserved. One is shot clocks with some consequences, so we don't sit around 24 years waiting for a rule with justifications. Another is forbearance. We certainly are of the view that Title II forbearance is a good thing, and we wish it were extended to Titles III and Title VI. Another, and it means that some rules, frankly, should be let go. We know we don't understand, for example, the need anymore to have most rules supposedly favoring localism in broadcasting. We don't know what it really means anymore in today's environment. Third would be to have merger review occur in one location so that it's quicker, so that money that's put into waiting with bank escrow fees for how many billions of dollars for weeks and weeks and weeks doesn't just go there, but instead goes to consumer welfare when mergers are dealt with more quickly. And fourth, this is interesting because of who it came from. Having a new member of the commission's staffs, an engineer, in their offices. Rob points out most commissioners aren't engineers. There's never been an engineer who's been a commissioner. This idea, and you think, well, my goodness, it must have been some liberalism. Let's have another layer of government and to promote science. It was Cliff Stearns, my friend, who proposed it in Congress, and to Congress's shame, and didn't adopt it, but it should. That's it.
David, thank you very much. I know it's not much consolation to you, or nor should it be, but when you were talking about how long some of your proposed actions have been pending, you know, if I had a bit of time, I could probably name 10 or 12 other commission actions that have been around for years and years. Commissioner McDowell, when I was preparing and I was looking at the special access proceeding, and you wrote a dissent or concurrence or something or not, but you said in there, you were talking about how long this thing's been going on, the delay in gathering data, and you said, quote, "The federal government's glacial athleticism is on full display." And that's, we could give a lot of examples, but I understand what you're saying. So next we're going to hear from Adam. And Adam, you will note, I hope you've noted, that I did not deliberately utter the word DACA here, or Digital Age Communications Act, because Adam's a former colleague of mine, and he helped develop, I know, a paradigm that we think is a statutory framework that's important to be considered. So I'm going to not say any more and turn it over to Adam.
Well, thank you, Randy, and I appreciate the invitation to be here today to speak at this event, and congratulations for everything that Free State Foundation has been doing on this front. So the fundamental problem we face in the world of communications and media policy today is the same problem we have faced now for many, many decades, and that we haven't ever cleaned up. This problem is both easy to define and, at least in theory, easy to remedy. The problem is quite simply that we have what economists and political scientists refer to as a asymmetrical regulation situation, or a classic proverbial unlevel playing field problem. Policymakers have been for a long time imposing differential regulatory treatment and policies on different layers of the information ecosystem. This goes back again a long, long way. If you want to go back and read Athil de Solopoul's classic work, Technologies of Freedom, in 1983, you'll see this problem perfectly diagnosed and remedies proposed that are going to sound a lot like what I'm about to say. Unfortunately, we haven't gotten around to solving them. But let's be clear about the problems that this asymmetrical regulation problem creates for our economy and for innovation. First, it is blatantly unfair to those players who suffer under the more onerous rules. Second, it threatens to roll those old, more onerous rules and standards and regulations on new platforms and new speech and communications technologies. And third, as a corollary to 1 and 2, it creates uncertainty and threatens innovation and investment throughout all of these information sectors. It also threatens free speech indirectly. So the solution, which again is simple in theory but more complicated in political reality, is that we need to level the regulatory playing field by deregulating down and not regulating up. Now let's get more concrete about how we might accomplish that. I'm going to suggest 2 little cute ideas here that I've been proposing for about 15 to 20 years, but unfortunately no one's been listening. So I'm going to repeat them again. About 20 years ago, when I got started in the field of public policy, I was not actually a tech and telecom guy, I was a trade guy. And in the field of trade policy, we know that the revolution in free trade globally that has taken place in the post-war period has been mostly due to a single principle, actually two principles, national treatment and a second one called the MFN clause, the most favored nation clause. Under most favored nation policy, basically you have to accord a trade partner the least restrictive sort of treatment, the least onerous treatment that you would accord to anybody else that has gotten good treatment from your country. So lower tariffs to one country have to be accorded to all, or the lowest tariffs or least burdensome tariffs, or trade policies. Folks, we need a MFN clause for telecommunications and media. We need to have a simple principle that says the least regulated sector or industry or company should be the standard by which the standard we accord to all of the players that it competes against today. Because we do live in a world of media and technological convergence. Everybody should be treated under the same low level of regulation and accorded the same equal treatment. So MFN clause would be my first idea. My second idea is we need Moore's Law for information technology laws and regulations. I think all of you are familiar with Moore's Law, which basically states that it's the general rule of thumb in the computing sector that the processing power of a semiconductor and therefore computers doubles roughly every 18 months or so, maybe every 2 years. What we need is a principle that basically says that every new technology proposal should include a provision sunsetting that law or regulation after 18 months to 2 years. Because if technology is going to move that fast in the information sector, then law ought to as well. And people say, well, what if that law or regulation is important? Well, Congress has the power to go back and implement it again. And I would apply that retrospectively as well. I think we should apply that standard to all communications and media laws and regulations. Every 18 months to 2 years, it should go. And then the third principle is a more straightforward one, and I know a more radical one, but we need comprehensive, not just reform of the FCC, but we need serious downsizing this agency. You know, back in the 1970s, when we comprehensively deregulated airlines and transportation in this country, I would remind all of you that was done by liberal Democrats. It was done by liberal Democrats, Fred Kahn, Ted Kennedy, Justice Breyer when he was a clerk in the Senate, and a number of other folks, including Ralph Nader, who wrote probably the most powerful piece on the need for deregulation ever penned, because he pointed out that public interest regulation in those fields had become an anti-consumer fiasco. And that not only did the regulation have to go, but they were so convinced of this problem that the agencies that oversaw these industries needed to go too, because of the problems of cronyism and everything else that goes along with the sort of regulation that was entailed in those sectors. They got it done. By 1985, the Civil Aeronautics Board was gone. By the early 1990s, the Interstate Commerce Commission was gone. So we're sitting around here, and my old friend James Gattuso has sort of given up on it, but some of us still believe it's a good idea to seriously cut away at the powers of the FCC and to at least limit them more stringently. Now, it wasn't that long ago that this wasn't such radical thinking. In fact, 17 years ago, we sat in a room, James Gattuso and I and many others, just across the hall here and released this boring little document called The Telecom Revolution, an American Opportunity, that was penned by 12 different think tank analysts talking about how to seriously downsize and reform the FCC by repealing most of its powers. And then 10 years after that, we came up with, again, Randy mentioned this, the Digital Age Communications Act project, which we released right over there. And Randy was a big part of that. He was really the brainchild behind most of this, along with Ray Gifford. And this project also proposed fairly sweeping reform of not just the FCC, but of all communications law. Really, DACA was a bit more of a moderate effort than the earlier Telecom Revolution project, because DACA was basically saying, look, at a minimum, the FCC should behave more like the FTC. And specifically what DACA proposed, and also the Telecom Revolution book proposed, was the idea that we should replace the public interest standard with more of a consumer welfare standard. That we needed to have well-established sort of antitrust law and competition law principles governing communications policy. Seems fairly straightforward. Personally, I think antitrust officials can do that just fine. We don't need the FCC. But if we're going to have the FCC, that ought to be rule number one. Replace public interest with consumer welfare standard. Number two, eliminate regulatory silos and level the playing field through comprehensive deregulation. Again, that goes back to my MFN principle and the idea that we've already talked about here of getting rid of all these silos that Commissioner McDowell has already discussed in his remarks. Third, comprehensively reform spectrum, not just through more auctioning, but by according unambiguous property rights in spectrum licenses, so that we can move away from the idea that the government's always allocating and dictating what you can do with your license. Fourth, comprehensively reform universal service. My preference would be by voucherizing it or devolving it to the states to create an honest-to-God telecom welfare program, which is what it's always been, but we just haven't been honest about it. Or at the federal level, getting a lot more strict about how we budget it for it. And then fifth and finally, again, significantly reform or downsizing the scope of the FCC was part of both of these projects, both DACA and the Telecom Revolution project. So, I mean, what these proposals and these projects stood for, by the way, DACA, 50 nonpartisan academics, left and right, combined to work on that project. So what both of these proposals and everything that I've been advocating here stand for is the proposition of what Richard Epstein has called in his book by the same title, Simple Rules for a Complex World. We can live with things like the common law, torts, the law of contracts, anti-fraud statutes, and antitrust. We get by with those in every other major capitalist industrial sector. But for some reason we say, communications and media is special, it's different. Well, you know what? I do think it's special and different. So did our founders. They thought it was so special and different that we got our First Amendment, which says Congress shall make no law. And for the longest time, that was the standard of our nation. But then the FCC came along and said, we own the spectrum, and we have to dole it out, and we need speech rules and the fairness doctrine, and we go all the way down to things like net neutrality, and we're surprised these things happen. They happened because we didn't get our first principles right when it came to communications and media policy. Thank you, Randy.
Adam, thank you very much. And I appreciate the way Adam brought up the MFN principle in Moore's Law, because that is something that when we talk about communications, we don't talk about it that way. And I think that's important. And we don't often talk about those ideas. I think they're important. We can envision a 3 or 4 sentence bill, right? MFN shall be implemented in Moore's Law. But since that may not happen, I'm glad you brought up DACA, and I appreciate the fact we've got a bipartisan contingent of congressional staffers here. So the key telecommunications staffers on the Hill, and I'm glad you're here. I will say that the DACA project is, as Adam knows, many of you in the room know. I'm not sure whether Commissioner McDowell does or remember, but that led directly. Senator Jim DeMint actually took it and introduced it as a piece of legislation back in 2005. His chief aide, Hep Rigby, is here, and we appreciate that. But I'm not sure if he knew that you described that as moderate. I'm not, which you did. I'm not sure he would have done it. But he took that piece and introduced. It was S2113, I believe, and. Hey, I think it's still a pretty good darn model that people ought to look at. So thanks for
not only is it a great model,
thanks for
but
talking
combined
about
with the bill that Senator DeMint has introduced along with Representative Scalise on the media front, you have in the makings a really beautiful model for what could be the Telecommunications Act of 2016.
Right. If you had a piece of tape or something and could put those two things together,
perfect.
You'd have a good bill. Now, what I want you to be doing, again, everyone out here, because I deliberately built in the time, is if you have questions or if you have a comment, reaction, I want you to think about it and ask. While you're doing that, I'm just going to ask this quickly. I thought it was a good question before about what needs to happen, politically or whatever it might be, to increase the chances for legislation. So, if any of you have, anything to add on that, or anything to say, I just think it's something we all should think about. Any of the panelists have anything to say about that?
If I can just jump in.
You could say an election. I don't know. Whatever.
I think that, is this on?
It's on, we can hear you.
Okay. I think it's key that the FCC act on its own first. We're talking about the Fred Kahn example, Civil Aeronautics Board. Kahn deregulated the airlines in effect before Congress deregulated the airlines. It was more or less a fait accompli. Congress is always hesitant to jump into the unknown, even when the argument is clear. So what Kahn did was he shone light on how a deregulated market would work. He had it well on its way, and Congress merely ratified that. So I think the FCC's actions are going to be the trigger, if there is one.
That's an excellent point, and that's why I was so happy to have Commissioner McDowell here and answer some of these questions. And because my view of the role of the commissioner, he's obviously has to follow the law when he makes a decision, but there can be there's a lot of discretion in the act, I think is what you're saying. And a lot of ways you can go either one way or another, and it can send signals to Congress. But one thing that there's a great book, maybe some of you read it, called Profits of Regulation by Thomas McGraw. And he's got chapters on 5 leading regulators, one of which, starting back with what's his name in the 1800s, Henry Adams or whatever. But he's got Kahn, and there's a whole chapter about Kahn that's really instructive on this point. But one thing that Kahn said, he quotes from a letter that Fred Kahn sent to President Carter when he really wanted to get things done, and he said, send me a few good men. I'm sure now he would say men or women, but and so it sort of emphasizing that personnel obviously are very important in this process as well.
We need binders.
Yeah. we need some binders of men, and don't take offense at that remark. David.
I'd like to try to answer that question as well. Probably, if you believe the polls, we're going to have for 2 to 4 years divided government. And we really can't wait 10 years to get another new Telecom Act. So, like it or not, we're going to have to try to get this divided government to agree on legislation. And while people feel very strongly about the way it should go, I think the way that you get legislation, and have always gotten legislation from a divided government, is by people being willing to compromise and work together and find ways to accomplish their objectives. Just to give you a few examples that we've talked about today. Maybe it's possible to get Congress to agree on a principle of platform neutrality. They may not agree that the default is the lowest level of regulation. Probably shouldn't be the highest level, but maybe it's somewhere in between, or there's some other way to define it. Or you leave that to the commission. Congress may not be able to agree on sunsets because it's hard to get legislation passed. Government can shut down, and then 18 months can run. But maybe you can get them to agree on forbearance. And it may not be possible to get Congress to downsize the FCC, but maybe they structure the budget a little differently. We certainly need more money, quite frankly, spent on the portion of the FCC that does merger review, because it takes so long because they don't have enough people with expertise. They actually need more people there. There are other areas where they probably need fewer. So it really is a granular analysis, which is the sort of thing that Congress is pretty good at doing.
Okay, do we have questions from the audience, comments? Okay, Paul, Scott, you've had one, so let's go to Paul here. Just identify yourself, Paul.
Hi, Paul Barbagallo with Bloomberg B&A. Question for the entire panel. Do you think Congress can agree on what the problem is in order to move legislation? Because in 1996, one of the problems was lack of competition in telecommunications markets, and one of the main goals of the '96 Act was to open up competition. And so I'm wondering if it's possible for Congress to, even before they get into really, talking about what provisions are going to be in the bill, what is the problem we're trying to solve?
Go ahead.
Well, I think there's a real problem there. I do think they're talking past one another once in a while, and I think both sides have to give a little before we're going to get something, because I think on the Democratic side you have a problem with a lot of sort of numeric counting of like how many competitors are in each sector, and a preoccupation with trying to plan markets preemptively, and a misguided notion that the public interest can be planned preemptively from above. I think they have to be willing to give a little and take a leap of faith the way Democrats did in the 70s and 80s on other types of regulation. The Republicans have a very different problem. The Republicans all too often identify the principles of consumer welfare and deregulation with what industry wants. And they are interested in trying to balance out interests, trying to figure out what one sector should do versus another and how to make all sides happy. That can't be done. All of those sides are going to have to probably bleed a little in a deregulatory world. But that's how we're going to get to a better world. But the problem is Republicans don't want to necessarily let go either. So, both sides are talking a different language.
There may be two principles that Congress can agree on, or maybe this is aspirational. One of them, Adam, in his comments, I think, just nailed perfectly, and that is that we've got static rules, but a very fast-moving, dynamic economy. We've never had technology move faster. Technology is now moving faster than the speed that regulation can keep up with it. So that is a new issue that hopefully people will understand. The other one is this, just to know about what market failure means, to define that and give it some flesh, more than is in 202H, but really to recognize some areas where they can declare the market has failed or is going to fail until certain benchmarks are reached, and others where they think that it has not failed and deregulation should be the default.
Okay, fairly quickly, James, do you have something, or Rob? You wanna?
Well, just real quick, I think we do need to be careful about pushing for a new telecom law as a goal. Congress does not have a good record with writing telecom laws. The 1927 Act, starting with that, was reducing competition. 32 expanded that. There wasn't another act for another 34 years. And the most successful parts of the industry after the 96 Act are just those two that were not mentioned, internet and spectrum. So we don't have a good track record here. I think instead of saying that our goal is to rewrite the Telecom Act and then work out what it includes, I think we need to identify the goal of what policy needs to be changed, and then if that takes Congress to do it, then you go forward. But the goal should be the reform, not the new act.
Okay, I'll just add my own view, and I think the commissioner identified this. There's a lot of agreement that the smokestack regime, which has different regulatory requirements attached to the different smokestacks, does cause some problems. And if that were eliminated and there were just some type of competition standard that worked across industries, that might be good. But that's just the moderator's point of view. Do we have another question, comment? From anyone? Scott. It's coming.
If railroads don't need common carrier regulation anymore, or buses or trucking or airlines, why are people thinking that or even considering that common carrier Title II is relevant in these days when all the other common carrier regulated industries were deregulated from that 20, 30, 40, 50 years ago?
Who wants to take them? Go ahead.
I'll
David.
get in trouble. Railroads were deregulated and airlines were deregulated because there were other means of transportation. There are still a lot of people in the country for whom their plain old telephone is the only means of communication. Now, when that's no longer the case, I think then will be a point that you've said.
But it was also true that we had certain stops for both airline hubs and railroads that didn't have a lot of competition, and yet we did deregulate and we eliminated most of those common carriage type principles. So, I mean, there's a preoccupation with trying to achieve some sort of perfect world with the perfect amount of competition and supposedly no discrimination. I mean, the reality is that we have a pretty good looking world today. We're lucky that we have as good a looking of a world considering how much regulation we still have. But I think it could be a better one if we freed up these sectors. But I think, again, I use the term leap of faith. I don't think we haven't been there. We were there for other economic sectors. And the interesting question from a political scientist perspective is, why is it that we took that leap and took it under Democrats for those other sectors, but then under times of Republican rule, we couldn't get all the way there and take it for communications? And Fred Kahn famously noted in that book by Tom McCraw, Profits of Regulation, that one of his biggest regrets is that he didn't take the FCC job instead of the CAB job. We might have been living in a very different world and having a different conversation had that happened.
If I can add also, the railroad example is a good one. Unlike airlines and trucking, the railroads were not completely deregulated. The ICC was transformed into what's now the Surface Transportation Board, which is tucked into the Department of Transportation and fortunately rarely heard from. But it does.
But had no powers. Right.
It has some powers, but exercises them in a very limited way, and is very, very constrained. And that was a way of getting past the objection that there are some pockets, and you can always find pockets where someone doesn't have, what's considered sufficient choices. So rather than let the whole, no pun intended, let the whole train of reform stop, the Surface Transportation Board said, okay, we'll address those specific problems, but we'll free the rest of railroad and trucking.
And importantly, antitrust law wasn't abolished. I mean, there have still been cases that have been brought
Yeah.
under antitrust law statutes
Yeah.
dealing with transportation sectors.
Right.
So that can still happen for communications and broadband as well.
Okay, we can take maybe just one or two more questions. And while you're thinking about it, I have something I want to ask, and anyone can answer it if they're inclined. When I was talking with Commissioner McDowell, there were several times when I was asking essentially this question, because there's discretion in the commission under so much, with regard to so much of its activity under the public interest standard, or even if it's forbearance when you have to look at protection of consumers, or on Section 11 competition. You know, these are terms that are not self-defined. I mean, competition is not defined as three competitors. Obviously, the public interest isn't defined. I mean, I'm putting aside the need for congressional action, which I think a lot of people agree on. But in the meantime, you know, the marketplace is moving, it's dynamic and so forth. So do you see, I've thought that with the right commission, and I don't mean that necessarily one side of the political spectrum, but with a commission that was amenable to regulatory relief, that it could establish more presumptions and operate that way. And I noticed when the commission just got rid of the program access ban, at least partially, and I just read the news release, but it seemed to me that for the parts it retained that it didn't get rid of, at least from the news release, it seemed to establish what it referred to as rebuttable presumptions, which I'm not sure are in the act, but just something the commission did, I believe. And that's what I was trying to at least think about. And so I'm wondering whether, does anyone up here is sympathetic to the notion that the commission as a general policy, and not just, I'm not talking about taking one case, but it could establish some policies of establishing rebuttable presumptions that the market is competitive absent convincing evidence otherwise. Adam?
Well, I'm hugely sympathetic to that, but I also think it's a tad bit naive. I mean, I'm out of George Mason University, or the home of public
That's why
choice
I'm in a think tank, and he's sitting down there.
Well, but out of George Mason, where we study public choice economics, one of the first rules of public choice is that basically regulators don't deregulate or defund or take away their own powers, right? There's not a good interest in doing so. You aggrandize power as opposed to actually minimizing it or limiting or tying your own hands. You have to have other institutional incentives or other institutional constraints imposed from outside if you want these sorts of reforms to be solid. And I was involved on Capitol Hill in the mid-90s in trying to get 706 and a lot more sweeping things pushed through. But it was always sort of like just some language we tacked onto the end to say, look, what we really need to do is constrain them from right here, but we didn't get what we needed to have done in 96. I mean, so you've got to have Congress assert some authority
Well,
here.
I want Congress to do that, but I guess what I'm saying is that's not going to happen, you know, by February of next year. It could be there's a new Federal Communications Commission, or what it may be. There won't be. But what I'm saying is they just established in this proceeding I just mentioned what they called rebuttable presumptions that work the other way towards regulation. And I guess I'm just saying in the meantime, if maybe there could be some rebuttable presumptions that were deregulatory in nature, given the discretion the commission has. Rob, do you have a reaction?
So in my typical inimical third way that I always try to push, I guess I would say that's probably more of a third way issue framing, Randy. I mean, Adam, we agree on a lot of stuff, like particularly COPPA, which if you're interested in COPPA, come to our event. But I think there is something different about networks, and I hate to even bring up net neutrality because, as you know, we were one of the biggest and strongest advocates that we didn't need strong net neutrality rules. But at the same time, there is the potential of abuse. I mean, these are networks that have a core function in the economy, and there's a potential of abuse. I frankly didn't think there was going to be abuse. I have yet to see, with the exception of one case, and that's Madison River, of any abuse. I just don't think it existed. But it's potential. It's possible. And I don't think antitrust is a regime that would allow one to deal with that. And I think this notion of what Randy's talking about, assume it's not going to be there, assume it's going to work, but, you know, have some capability of stepping in if one needs to. And now, you know, your public choice argument is a good one, I grant that. But I do think this isn't just simply like other things. I mean, I think generally the market's working in these cases. And we should assume that that's going to continue to be the case. And it probably will be the case, but you never know. And I think that's why we have an FCC.
Do you think we need a return of sectoral regulators for airlines and transportation, service transportation? Are we not in a better world today because we don't have sectoral regulators that are captured by industry interests and doing misguided things like creating cartels?
Given the fact that I once rode a Greyhound bus from San Francisco to Florida to visit my parents when I was in college because the airline prices were so high, I'm totally with you.
That's awful.
But I think it's a different industry.
Okay.
Okay, do we have a final question, and then I'm going to wrap it up. Anyone else have a question anywhere? Okay, now I want you to disprove the notion that Twitter handle was too long. It's FSF October 18 FSF. No, Ideas Forum. It's on your sheet. Thank you, and give this panel a big hand, please.